Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So, what are we going to be talking about today? Well, stand your ground. I'll have more on that in just a second. Now, every now and then, a case will come along that pops up under one of the many different states' version of Stand Your Ground. In South Carolina, they call it the Protection of Persons and Property Act. And it provides for not only criminal immunity, but civil immunity in the case where someone is found to have been justified in their use of deadly force. But one of the problems that happens when people who don't really understand courts and how they operate, one of the things that happens is that the law gets passed without any indication of how the legislature intends for that law to be applied. Now, in many states, you have specific procedures, and it's spelled out in the statute, but it isn't spelled out under South Carolina's Protection of Persons and Property Act. And so today we're going to talk about a case involving a gentleman who, for whatever reason, was found guilty under as for basically second-degree murder, and the conviction was overturned by the South Carolina Supreme Court. So John McCarty lived with one of his with his life partner, and his life partner occasionally liked to have a beer or two, and he had some people then in that he had invited in. They were guests in the house, and he needed some help because he had suffered a neck injury several years earlier, and he was somewhat disabled from that neck injury. He had actually broken his neck. And any of you who are familiar with a broken neck know that it can produce many, many complications later on in life when those bones heal and then they develop calcium deposits and it pushes on the nerves. It can be a real wreck. So he had brought these people in, and as a result of that, two of them who had also been drinking got into a little bit of a tiff with him, with the partner. His name was Wilson. So the partner, who is having this little run-up with, I believe his name was Brandon, he basically tells this guy that he needs to get out. He needs to leave the trailer that they're living in and take his stuff and get out. So in order to make that happen, he goes out and fixes the gentleman's car. Now, that's not a very aggressive action. Going and fixing someone else's car is actually kind of a nice Christian thing to do if you really want them to leave. And apparently he really wanted them to leave. So he went out and fixed the car. And as he's trying to come back into the trailer, up the steps of the trailer to get in, these two people who he had invited in, who he was now kicking out, they attacked him. Now, prior to this attack, the police had come and said, look, we can't force these two people to leave. You can ask them to leave, but we can't force them to leave. So the police left. The police have left. There's nobody there to monitor the situation. And Mr. McCarty, who is the defendant in the case, is back in his bedroom. He'd worked a long day. He was back in his bedroom sleeping. During the attempt by Mr. Wilson to get back into the trailer that he lived in with Mr. McCarty, the other two decided that that would be a really fun time to punch him. Now, apparently there was some assertion that he had done something aggressive by knocking one of the person's cigarettes off of the railing, but it was just as reasonable to conclude that he had slipped or he was using the handrail and accidentally knocked them off. Whatever the situation, Brandon and his buddy didn't like that and started wailing on him. They actually knocked him back down the steps and he broke his foot. So now he's got a broken foot, he's in pain, He's got two people who've been whooping on him, and now he calls out for his partner, John, and he tells him, hey, they're killing me out here, words to that effect. John, who's been sleeping, hears a tone in this man's voice that he's never heard before. He's never heard him be this panicked or this scared before. So he grabs his pistol and he goes out, and after trying to make them stop by yelling at them, he fires a shot into the floor. Now, nobody who is a self-defense instructor advocates firing a warning shot. But here, at the very least, it demonstrates an intent not to kill someone. When the warning shot had no effect, he fired twice through the door at the persons who were trying to prevent the other man from getting back in the house, and unfortunately, Brandon got killed. So, South Carolina has this immunity provision, and Mr. McCarty asked to be exonerated under the immunity provision, which requires the circuit court to hold a hearing. It requires the judge to hear the evidence, weigh the evidence, and determine whether immunity is appropriate. Well, there was a conflict in the evidence somewhat, in that one of the people testified that he knocked his cigarettes off, and another one said no, he just, he basically slapped the rail and they fell off. It wasn't intentional. But the rule in South Carolina, and this is really important if you engage in defense of others, because remember, Mr. McCarty was not himself in danger. He wasn't getting wailed on. It's really important to remember that in some states, and South Carolina is one of them, you are only authorized to come to the defense of a third party if the third party would be entitled to come to their own defense. Well, the judge determined that he couldn't make a decision. He felt like it was a jury question. So in a murder trial, that's certainly a jury question. But the issue was whether immunity applied. And so turning it into a jury question completely nullifies what the statute intends, which is an early determination that immunity is appropriate. So Mr. McCarty was convicted and sent to prison, and he appealed to the South Carolina Court of Appeals, and the South Carolina Court of Appeals rubber-stamped the trial judge. And this happens fairly frequently at intermediate appellate courts. They have a busy calendar, and a lot of times they don't look at things in the depth that they probably should. So Mr. McCarty's lawyers, who were public defenders, took a writ of certiorari to the Supreme Court of the state of South Carolina. And the state of South Carolina said, well, the legislature never told us how to handle this immunity provision, so now we have to determine how to handle this immunity provision. And in a prior case, one that was actually decided before this case went to trial, they had determined that the trial judge has to weigh the evidence and make that determination. And in this particular case, they did not do that. The trial judge did not weigh the evidence and make the determination. He abdicated his role as the judicial fact finder, and the court found that was not appropriate. Now, Mr. McCarty, realizing, of course, that he had been granted an opportunity to petition the Supreme Court, decided not to go for half a loaf. He said, look, I not only want an immunity determination, I want you to kick me loose, because clearly I was entitled to immunity. Well, the South Carolina Supreme Court would not go that far. They said, we will grant you the new trial. We're going to remand this to the circuit court for the circuit court to determine whether and to what extent you are authorized to have immunity in this case. So it will be interesting to see what happens in the circuit court on the immunity issue, and if indeed the court makes a determination that immunity applies. And if indeed the court makes the determination that immunity applies, the case is done. And if it makes the determination that immunity does not apply, then the conviction would be reinstated, and Mr. McCarty would have to appeal that determination separately from his conviction. So that creates a situation where either way, they are probably going back to the appellate courts to decide this issue. And I think that is probably not what is in the best interests of justice here. It looked to me like this is really a fairly clear case of stand your ground. Even the person who testified for the state, who was the other person causing trouble, said, look, it was just supposed to be a fist fight, and the other guy kind of got out of hand. The guy who got shot got out of hand. So I think it will be interesting to see what the South Carolina District Court or Circuit Court does with this, and we'll have to see. I'll try and keep this on the radar and let you know if they issue an opinion later on. Thank you very much for watching. I appreciate your contributions to the channel. If you have any questions, please leave them in the comments down below. If you haven't already, please give me a thumbs up, like, share, subscribe, all those troublesome things that people on YouTube ask you to do. And if you are a self-defender, make sure you go to the range. Make sure you practice. Because the fact of the matter is, a self-defense tool doesn't do you any good if you aren't any good with it. That's my little bit of wisdom for today. Thank you again for watching, and have a terrific day.